Is it contempt of court if a custodial parent failed to meet with the other parent for parent time or a custody exchange? Well, in this case, there was car trouble and they were living 100 miles apart. So in that case, I'll answer this question based upon the law of the state of Utah, where I practice divorce and family law. The law governing contempt of court in family law settings is this: to find one in contempt of a court's orders, in this case an order regarding the custody and parent time schedule, one must show by clear and convincing evidence that the person cited for contempt knew what was required, in other words, knew what the court order is, had the ability to comply with the court's order, and intentionally failed or refused to do so. Footnote here. So if a parent proved that he failed to return a child at the end of a joint custody period or at the end of a parent time period through no fault of his own, but due to his car breaking down unexpectedly, i.e. unforeseen circumstances that were beyond his control, that parent could not be held in contempt of court because while he knew what was required, he neither had the ability to comply with the court's order at the time of the unforeseen breakdown, nor did he intentionally fail or refuse to comply. And here's the footnote. Here's some case law on the subject of civil contempt of court. Quote, as a general rule, in order to prove contempt for failure to comply with a court order, it must be shown that the person cited for contempt knew what was required, had the ability to comply, and intentionally failed or refused to do so. Closed quote. The district court must make, quote, explicit findings, whether written or transcribed, on the three elements of contempt. Close quote. See the 1988 Utah Supreme Court case of Von Hake v. Thomas, 759 Pacific Reporter 2nd at pages 1162 and specifically page 1172. In a civil contempt proceeding such as this one, those elements must be proved by clear and convincing evidence. See State v. Hurst, 821 Pacific Reporter 2nd, page 467 and page 470, which is a Utah Court of Appeals case from 1991.